Hello everyone. Today I am going to speak that is on Business Regulatory Framework, and my topic is Indian Contract Act 1872. So now what is contract? So according to section 2 subsection H of the Indian Contract Act 1872, a contract is an agreement enforceable by law. So to be enforceable by law, an agreement must satisfy certain conditions. So these conditions are called as essentials of a valid contract or legal rules of a valid contract. So meaning of the contract is an agreement between two parties which is enforceable by law. Without enforceability, there cannot be any contract. It's only called an agreement. So agreement is offer and acceptance, and the contract is offer, acceptance and enforceability. So the essentials of a valid contract are laid down in section 10 of the Indian Contract Act 1872. So according to this section, all agreements are contract if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not expressly declared to be void. So essentials of a valid contract are as follows. First one is plurality of parties. As stated earlier, contract is an agreement enforceable by law. An agreement is constituted by the other party, means there must be at least two parties for a valid contract. That is, one to make an offer and the other to accept that offer. Second is offer and acceptance. An agreement is a preliminary to a contract. That is, to constitute a valid contract, there must be an agreement between the contracting parties. To constitute an agreement, there must be a valid offer by one party and a valid acceptance of that offer by the other party. Now what is this offer? When one party signifies his willingness to do or to abstain from doing something with the view to obtain the assent of other party or consent of other to such act or abstinence, he is said to make an offer or proposal. Now what is this acceptance? When the person to whom the offer or proposal is made signifies his assent thereto, then the proposal is said to be accepted. Third one is intention to create legal obligation. The agreement, the contracting parties must be intended to create legal obligation or legal relationship between them. If there is no intention to create legal obligation or legal relation, there cannot be any contract between them. This point has been confirmed in the case of Balfour versus Balfour. What the case says here? In the case of Balfour versus Balfour, Mr. Balfour, who is a defendant, was a civil servant stationed in Ceylon. He and his wife went to England to enjoy the holidays. When they were about to leave England, that is to Ceylon, Mrs. Balfour fell down. So she fell ill and so couldn't accompany Mr. Balfour back to Ceylon. So Mr. Balfour asked Mrs. Balfour to stay back in England and promised to pay £30 a month, that is for the maintenance during the time they were forced to live apart. So after returning to Ceylon, Mr. Balfour sued Mrs. Balfour sued Mr. Balfour for breach of agreement, because there was a contract, that is the agreement between the Mr. Balfour as well as Mrs. Balfour. Her suit was dismissed, that is by the court, on the ground that there was no legal obligations that was contemplated in the agreement between the husband and wife, and so there was no contract. Obviously, marriage contract is a contract because it is a commercial. Marriage contract is a commercial. Okay, so it is a contract. But the agreement between the husband and wife, it cannot be a contract. It's only an agreement. Okay. So fourth one, lawful consideration. So as per section 23 of the Indian Contract Act 1872, subject to certain exceptions, agreements to be enforceable by law must be supported by consideration. Now what is this consideration? Consideration may be in the form of cash or in the form of kind. So it may be noted that consideration need not necessarily be in cash or kind. So it may be an act, that is to do or not to do something. Again, the consideration must be past, present or future. Consideration is lawful unless when it is forbidden by law, when it is of such a nature that it would defeat the provisions of any law, if it is fraudulent, if it involves or injury to the person or property, opposed to public policy, and if it is immoral. Fifth one is competency or capacity of the parties to enter into the contract. So who are the parties are able to enter into the contract? The parties to an agreement must be competent to enter into an agreement. That is, the parties to an agreement must have legal capacity to enter into an agreement. In order to be legally competent to enter into an agreement, the parties must be of the age of majority, must have sound mind and must not be disqualified by any law to which they are subject to. So, persons suffering from any flaw of capacity like minority, lunacy, idiocy, drunkenness, etc. are legally not competent to enter into the contract. Sixth one is free consent. So what is this free consent? In order to be enforceable by law, agreement must be based on the free consent of the parties. So this essential signifies or implies two things here. Firstly, agreement must be based on the consent of the parties thereto. And consent of the parties means that the parties to the agreement agree upon the same thing in the same sense. Secondly, not only there must be consent of the parties to the agreement, but the consent of the parties to the agreement must also be free. The consent of the parties to the agreement is said to be free when it is not caused by coercion, undue influence, misrepresentation, mistake and fraud. If the consent of the party to a contract is obtained by coercion, undue influence, misrepresentation or fraud, then the contract becomes voidable. So, let us continue in the next class. Thank you.